This hearing opens with a plea for a second chance. The defense argues that the defendant has made a personal commitment to change and they're willing to stake their own credibility on it.
I'm just asking the court to allow him to move forward from today. I'm willing to work with him. I believe in him that much. At least I will work with him. And at this point, this is not third, fourth, fifth. We're asking he be given an opportunity from today. I can't change anything from yesterday or before. I don't know what the future holds, but I know right now, I feel he's made a commitment to me, and I'm going to make a commitment to the court that I will work with him.
The judge reviews the case. This is no ordinary DWI. With prior convictions, the charge is now a third-degree felony carrying up to 10 years in prison, though an agreement caps the sentence at 6.
24 CR 1389 is called the State of Texas versus Larry Fontanet. That's you, sir?
Yes, sir.
Present with your attorney, Mr. Grove, and the state's attorney. Earlier, you pleaded guilty to driving while intoxicating, operating a motor vehicle while intoxicated, and you have 2 or more prior convictions of DWIs. So this is a third-degree felony, which carries with it up to 10 years in prison. Plea agreement has been formulated by the parties. Whatever sentence shall not exceed a cap of 6 years in prison. So you were looking at no less than 2 nor more than 6 years confinement in prison. And deferred or unadjudicated probation is not applicable, but regular probation is.
Yes, sir.
Correct?
The court goes through the defendant's long record: multiple DWI convictions, suspended sentences, revoked probations. Each time, another chance, and each time, another failure to change.
You were looking at no less than 2 nor more than 6 years confinement in prison. And deferred or unadjudicated probation is not applicable, but regular probation is.
Yes, sir.
Correct? Everybody?
Yes, sir.
So you could be sentenced up to 6 years in prison, and that could be suspended, and you could be placed on regular probation. Again, the parties have reviewed this pre-sentence report. Is there changes to it? No?
No, you're right. Not from the state.
And it's made it part of the record for all purposes. I'm looking at your history, adult criminal history, sir.
Yes.
And it looks like in 2012 you had a DWI third in Jefferson Parish, and you were convicted and sentenced to 10 years, and then that was suspended for 8 years probation, and then 2 years confinement with 2 years probation, which I don't understand what happened there. Then in 2014, another DWI third in Jefferson Parish, and you were convicted in 2015 and sentenced to 10 years confinement in prison. Is that correct?
Yes.
Thereafter, in 2018, another DWI third occurs, I guess, here in the 252nd District Court sentences you in 2018 to 4 years confinement in prison. And then now this is the 4th DWI third that you're facing, right? This is the 4th time you've been held accountable. The 2013 Jefferson Parish conviction, the 2015 conviction in Jefferson Parish, the 2018 conviction next door in the 252nd, and then this one will be your 4th DWI third. So it's 3rd, 4th, 5th. This will be your DWI 6th, right? It's 6th, 3rd.
Well,
I mean, you've had at least, you have a DWI third, so that would be 3 or more.
mhm.
So you've had now 3 more convictions after that of DWIs since your first one in 2013, right?
Yes, sir.
Well, what's the problem?
And then I used to drink a lot.
No, I thought that now.
Yeah. And
Here we are now in Jackson. You moved over to another state.
Police found him unconscious behind the wheel, foot on the gas, more than twice the legal alcohol limit. The defense stresses he's kept a job, supports 9 children, and just needs treatment, not prison.
Here at 12:50 in the morning, the police come behind you. You're stuck in the turning lane on Gulfway Drive in Port Arthur, and you were unconscious.
yeah,
Asleep. The vehicle was running, your foot was on the gas pedal, and you had a 0.17 blood alcohol, which is over twice the legal limit. Okay. All right. So it's what we're looking at, a cap of 6 years in prison. So go ahead. Mr. Grove, you may go first in the state. And God bless you.
Judge, as the court said, this is already noted. Mr. Fontenette has a drinking problem, and yet, if you look at his entire criminal record, this is the only problem that he really has. I'm not saying that means that it's not a problem, but he doesn't have the other problems that most people have. In fact, on the drug usage, it shows that he has smoked marijuana as the only drug usage on 2 occasions. He has a couple of theft by check cases early on, back in '04, and it's very unfortunate that he does have this problem, but that's his problem. He also has been able to graduate from high school. He's maintaining a job. He's still working. He's worked during this entire time and has actually driven and been driven. Not he hasn't made all trips, but been driven with an intoxilizer from Louisiana to come to court over here. And he has 9 children that he supports. He takes care of them mostly through monthly child support. He's currently married.
How is he being a good father and helping the kids and supervising the children when he's unconscious in Port Arthur at 1 a.m. with his 4th DWI 3rd?
The judge presses hard. How can you claim to be a responsible father when you're risking lives on the road? The defense asks for one last chance through alternative programs. The state argues probation has failed 4 times already, and now public safety comes first.
How is that responsible parenting?
well, I gotta
They
work.
kind of need you at home, not to be in jail and prison, sir.
Yes, sir.
But you know, you've been there. You know what happens
Yes.
when you get intoxicated and you're caught. You go to prison now. Okay. So, you know, I mean, it's the family that's suffering here.
But that day, I gotta work. I work 16 hours. I gotta work like 10:30, 11 o'clock at night.
So what's your point? No, what's your point? That doesn't give you the right to commit 3rd-degree felonies.
Yes, sir.
Okay.
Judge, he's not denying that he has this problem.
What's he done about it after the? This is
He
the
hadn't
fourth
been able to
one.
get rid of this problem. But Judge, I think I would point out something that the probation officer raised in the pre-sentence report, and that is that basically the pre-sentence report's not bad until you get to the drinking problem. But there's been a number of things that he has not, had any help with, and some of which are recommendations made by the probation department. Some of these are things like the substance abuse felony punishment facility, and some things like this to help him deal with this part of his personality is what I would call. I don't know what, I don't think that's right in terminology, but he still has been able to maintain employment, take care of his family, and do all this other stuff. But he has this alcohol problem, and he can't get rid of that alcohol problem, obviously, by himself. He's been to prison, and that didn't take care of it. I would ask the court to give him one last chance, and that's to try some of these other alternative programs. Because except for that, we would be a whole lot better. And I think society would be a lot better if he could take care of this one part of his problem. Or and it's the kind of thing, Judge, that I'm not trying to say, oh, it doesn't matter, because obviously it does. It's very, very important. But this is something that just screamed for help. And I think it appears that he's done just about everything he can by himself. Now, that's not to say that it's not his fault, because it is. And he admits that it's his fault. He's not denying it at all. And I know that after Mr. Laird has some comments that Mr. Fontenette would like to address the court.
Go ahead. Anything, State?
Judge, when was he supposed to get this help after which a DWI? I mean, he's had so many opportunities to get help. He's had opportunities to change his ways and turn away from it. And all he does is keeps doing what the probation office, which the defense attorney neglected to do in the recommendations, talking about the fact that he has continued to drink alcohol, consuming alcohol in an irresponsible and dangerous manner. He's putting so many people at risk every time he does this. He's had every opportunity under the sun to get his act together and to do something for his 9 children that he keeps saying he wants to do something for, but he just keeps going out and he's going to end up killing somebody. And this is not for us to say he needs help. He's had a chance to get help. Now we just got to get him off the street so that he doesn't kill somebody. So we would ask for the 6 years. And I might add that this is not my case. And if I had this case, that offer would not be as generous as it is, looking at his past history. He would be looking at a lot more time, and there would be some enhancements with those prior felony DWI that he went to prison on to make him face 2 to 20 instead of 2 to 10.
Did you want to say anything, Cynthia?
I'm just asking for the state to help me. Just give me one chance to help me clean up my act.
Anything else? You have been placed on 4 separate probations for these offenses. And you want to go on probation again. You've had 4 separate opportunities to fix this mess. The last time you were on probation, it was revoked in Jefferson Parish. You probably had enough. And I opened the door for you. I opened the door for everyone.
The judge delivers the decision, guilty beyond a reasonable doubt. The 6-year prison cap is imposed immediately, with no delay to get affairs in order. The judge reminds him that every prior chance was wasted.
Nobody. You're supposed to fix it the first time. But you had a second time. You had a third time. You had a 4th time. And now here it is again, the 5th. And what's fair for you is fair for everybody. What's fair for you is fair for everybody. They come in and they go, I want the Larry Fontenette rule. I'm here for the 5th time. I failed 5 times, but I want probation, and you've opened the door, and it's good for one, it's good for all. You needed to fix it the first time. You didn't. Well, the 2nd or 3rd or 4th. Here we are. You pleaded guilty voluntarily. You were mentally competent to do so. You understood the consequences of pleading guilty. And there's sufficient evidence supporting your guilty plea from State's Exhibit 1 to find you to support your guilty plea, to find you guilty beyond a reasonable doubt. of paragraphs 1 and 2, the third degree felony of operating a motor vehicle in a public place while intoxicated. And I'm sorry, sir, but David, Mr. Grove talks to you about being your family. You have a family at home. This is after midnight. You're unconscious on Gulfway Drive for your fifth or sixth time. And you are doubled the intoxication rate, but now you want to use your family as somebody, as an entity that protects you from being responsible. It's not going to happen. You've had your chances. I find you guilty beyond a reasonable doubt.
You good. The reason why I'm there late is somebody asked me to drop him to the hospital, and that's why I ended up dropping him. That's why I was out late that night.
What were you doing drinking? You were twice the legal limit. You're not supposed to be operating a motor vehicle like that. But you've known it. It had, you know it. I'm not going to wail on. This is so clear. Nobody comes in here with these many chances. You're supposed to fix them. But here, this isn't a good reason after all of this has happened. And you're supposed to, the punishment goes up each time. And I'm following this agreement. You are hereby found guilty beyond a reasonable doubt of this third degree felony. And I'm following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 6 years. You'll be given credit for all time you have served in this case. But I feel I feel sorry for the family, but you have created such a lengthy history with all opportunities, with four separate probations that you should have learned from.
So I can get 30 days to get my little affairs together.
No, sir. No, sir. I'm treating you like everybody else. You don't have time to go report this. You're in custody now. You're going to serve out your sentence. I just wished you would have learned 4 DWIs ago that, but you know it has consequences. You know it does. And you know it keeps getting worse. And you still put you and your family in jeopardy.
We'll take care of that.
New information emerges. The defendant also tested positive for cocaine and THC. The judge notes this is serious and reinforces why leniency is off the table.
We done something with this?
No, I don't have any notes on file.
Here, he's tested positive for cocaine, bencyclidine.
This is mine.
Yeah, you have that. I don't remember getting this, but because I do something pretty quickly with this. No, that's not good. I mean, that's really bad. Plus THC, tetrahydrocannabinol, tested positive for 3 different things.
It's back in June. This drug patch. These are drug patches.
They didn't talk to you about this? They didn't tell you this? It says it was reported on July 23rd, a couple of weeks ago, but
Yeah.
I don't remember seeing it, but it's highlighted in here. I mean, that's serious. This is real serious. This is about as serious as it gets.
Yeah.
I've
been working with him.
I'm sorry.
He's just got a job.
I'm sorry, but he's got to pay for the mistake.
I understand.
Okay.
But
All right.
we've not been privy to that.
I just noticed it myself. I don't know why it was sitting in there that long. But it's going to get dealt with. We got to deal with it. First thing he's going to have to do is we're going to test him right now.
Okay.
But still, that's a problem. Because I don't know what else we can do. We got him on a drug patch. I don't know what more we can do. Test positive and you go there, in there.
Okay.
Anyway, have a seat. Got to deal with this. We call 24 CR 2385, the state of Texas versus Leon Goodman III, who did well today. What happened on all this other stuff, though? Did you see this?
I just saw it today for the first time.
You need copies of it. So.
Yeah. May I speak, Your Honor? Your Honor, I met Leon about May, early May. He was in my neighborhood. He lived near me, and he did some work. And I began to interact with him, and I sensed something about this young lady.
Good or bad?
Good. He's working. He's gotten a job within the last 2 weeks. He's with his mother and younger brother. It's just the three of them. And he's trying. He's been contacting me every week since I've been on this case. I believe there's hope. I believe he's a good young man. He just needs some guidance. And his test results show he's clean. We're asking that.
These.
Huh? Not those. But
This is June 24th.
But today,
I know.
he tested.
But,
and he's clean.
yeah, he was supposed to be clean before he got tested positive.
I understand that, but
do you understand? Do you understand that you're not supposed to be using drugs? That's a condition of your bond. Huh? What did he say?
He said no one told him that.
Yeah, they do. But nonetheless, they don't have to tell you using meth is wrong and a crime or cocaine. Sir, come on. You're in the big leagues now. We're talking about people going to life imprisonment here or the death penalty.
In a separate case, another young defendant faces drug issues. The court refuses special treatment and insists he be handled like everyone else. Routine testing, no exceptions.
This is what happens in this room. Well,
Your
buckle up. You're going to be held accountable. You understand? You're going to be held accountable for your actions, just like I would be. He would be. We all are.
Honor,
We make foolish choices.
he's willing to take tests every week.
Well, he doesn't have a choice if he's willing or not. If I understand, he's going to have to do it.
I understand that.
But
what I'm asking right now,
how do we withdraw this stuff? How do we undo this?
because he's clean now.
No, it's.
I don't know about the patch, Your Honor.
Hold on. You're saying this like, just let me out. I'll never commit another crime again, and I make a promise. That's not what this is. It's got to be more than that. It's got to be more than this.
I don't know what all was involved in it. I don't know about the patch. I know there have been bad patches before. I'm not saying that this is. I'm just asking the court to allow him to move forward from today. I'm willing to work with him. I believe in him that much. At least I will work with him. And at this point, this is not third, fourth, fifth. We're asking he be given an opportunity from today. I can't change anything from yesterday or before. I don't know what the future holds, but I know right now, I feel he's made a commitment to me, and I'm going to make a commitment to the court that I will work with him. And that's all I'm asking.
Okay. What's that say?
Judge, since he's clean today, we just put a 0 tolerance on him to make sure that we go testing regularly for a little while. Make sure that he stays clean. I think he's still got the patch on him. We'll see how the patches test out. He's currently on.
May I ask that we either do something with a new patch but he's willing to come in each week to have drug tests. We'll go to probation. Let him go to probation.
We're gonna do what we do with everybody else. He's not gonna be treated any differently. He's gonna be treated like everybody else. And we change out the patches, and
That's fine.
we're not gonna make special arrangements. You treat it like everybody else because it's been working fine. The method works fine.
Well, I'm just a little concerned. I've heard about bad patches, and this.
When you give me some medical science on that, let me know.
Okay.
I know what I hear, but
Okay.
I hear a lot.
I understand.
That we throw out the back window because it makes a good story.
I understand, John.
But we're talking about science here.
Yes.
So what are we going to do with this case?
We're just asking reset. Let me make sure we have. This is the first setting for me.
Yeah, it's just. Yeah, it was indicted in December though. See, how can it be the first setting? What happened? I mean, this is 7 months down the road. We're 8 months. We're in the 8th month of this.
I didn't show anything excessive in one process.
I came in June.
But there were other attorneys before you. Apparently, Langston was in there.
Well, I'm just saying this was my first setting, John.
But we're 8 months into this, so we just don't change lawyers and start from scratch again. How much time do you need?
Give it 30 days.
No, you got 6 weeks.
That's fine.
But Langston, how long was Langston Adams your attorney? For a while? A few months? He may have some information for you.
Okay.
He may have some information for you that you need to put in your file.
I'll find
Get a
it.
resetting.
Thank you, Judge.
Okay. You're still under those requirements for patch, so. We now call 22-39989.
A different defendant appears on a charge of sexual assault of a child. The legal discussion turns to whether probation is even an option, but the state highlights the seriousness of the crime and asks for prison time.
State of Texas versus German Mesa Salinas. You are Mr. Malinas, Mr. Mesa Salinas.
Yes.
Do you speak English fluently? No.
No.
You speak Spanish?
Sí.
Habla español.
Sí.
Perfecto.
Okay.
Muy bien. Muy bien. Okay. You speak good Spanish.
Yes.
We have an interpreter. Please and state your name for the record, please, ma'am.
Erica Birch.
And Ms. Burge, raise your right hand. Do you solemnly swear or affirm that you will interpret accurately the proceedings here in this matter involving the state of Texas versus German Mesa Salinas, and you will interpret for Mr. Salinas into the language he understands most, which is Spanish, and his translations from Spanish to English. And will you do that correctly? So help you God.
Yes, sir.
Thank you. Think. Earlier in this case, the defendant pleaded guilty, correct?
That's correct, John.
Just want to make sure. Mr. Salinas, you were charged with the second degree felony of sexual assault of a child. Earlier in this case, and I believe it was you can't make this stuff up. Look at the top. Look at the date on the top of that. What was the date? He pleaded guilty. It's not on the jacket, and it's cut off on the top of the page. It may be July 7th, but
Sure it was. What was it, July 7th?
Yeah, July 7th is on the second.
on July 7th, last month, Mr. Salinas, you entered a plea of guilty to this charge in this indictment 22-39989. A pre-sentence report has been prepared. Have the parties had an opportunity to review it? Are there any corrections or changes to it? The state of Texas?
Not from the state, Judge.
Defense.
Date has, the defendant has reviewed it, no changes.
It will be made a part of the record for all purposes. The agreement in this case is that whatever sentence shall not exceed a cap of 5 years in prison. So we're looking at no less than 2 nor more than 5 years confinement in prison. Is probation eligible on this? Deferred, what about regular probation? No.
Deferred.
She was 14 at the time, so if it's under 14 that I think you're not. You looked at it?
Sexual assault
Okay.
with a child is, you can't get, I don't think the court can give regular.
No, I don't think so. I'm
Okay.
talking about,
It's deferred.
Yeah, you can give deferred
You can give
what
on a second
options
period.
are available, and deferred is 42A.102. Eligibility for deferred adjudication community. In other cases, the judge may grant, in Part B, in all other cases, the judge may grant deferred adjudication community supervision unless, and under number 2, the defendant is charged with an offense under section 2.01, which is what he's charged with. Do you see that? 42A.102. Subpart B,
Subject to B. He may grant it on 22011. And subsection B is, where's the part?
in all other cases, the judge may grant deferred adjudication unless, 1, he's charged with an offense of those, and then number 2, the defendant is charged with it's number 2, parenthesis 2, large A, is charged with an offense under section 2111, 22.011, and that's it. That's the statute.
You're talking about subsection 2 down here, the defendant's
Okay.
charged with?
Yeah.
And you have to go past that and it says and. As previously
Okay.
requested on community supervision.
And B, okay, yeah. That doesn't, that,
That one qualifier allows him to get the purpose.
yeah, that much means eligible. So those are the options: deferred or unadjudicated probation, or no less than 2 nor more than 5 years confinement in prison. All right, State.
The defense frames it as a consensual relationship, says the man has been honest and hardworking, and pleads for deferred adjudication instead of prison. The judge will decide whether his admission earns mercy or punishment.
Judge, this is a case where this was a consensual relationship, was known by the victim's father, evidently, according to the defendant. I don't see anything from the victim's father in here saying that, but looking at it, I don't think that the defendant appreciates this being a crime. He says in his statement he didn't think he was doing anything wrong because everybody knew about it and he was doing it. But the child was 14 and he was, I think, 31 at the time. And that's just not legal. It's not moral. It's just not right. But taking into consideration of the fact that this was a consensual relationship, the state has limited his exposure to 5 years. But unfortunately, I think looking at this, you just can't get away from the fact that this was a child and that the child wasn't old enough to make the decision that she made to enter into a relationship with someone, and no one else protected her. So we would ask for the 5 years prison. I think that's fair under the circumstances.
Go ahead, Mr. Berman.
Your Honor, as the pre-sentence report states, that he has been here legally since 2010. He is a laborer. He works hard. I don't know what happened in Illinois and what even that obstructing identification or justice, but it was non-prosecuted back in 21. I don't have any idea what that is. But he basically has not been in trouble. This was probably more, it was consensual, but he worked for his the girl's father. He lived actually at their house. He asked for permission, and that's probably the reason why they had not gotten any response back from the family itself. Something happened, I think, between Dad and him in reference to work or something else. And then this charge was filed. The girl did not want to be involved, but problem is the girl's age. This wasn't just a one-time deal. If you had looked into it and with the police report, this was an ongoing relationship. In fact, they probably would have ended up married, good, bad, indifferent, illegal. I'm not telling you that it's right or justified, but that's just the way it happened. One of the things too, Your Honor, is that when he was approached by law enforcement, and I believe this is on page 1, he did not try to hide it. He did not try to run away. He was forthright with law enforcement and told them exactly what was going on. So to his benefit, he has stepped up and admitted that now he understands. Since I've been representing him, I've gone over, I explained to him in reference to being in the United States that you can't be doing this. He understands, and based on that understanding in reference to the age, he has accepted responsibility. We are asking for 10 years deferred in this case because I think it's granted. I think it's justified under the circumstances. I did have, and this was an ongoing with Mr. Eckert in reference to coming back and forth and coming to this agreement. And so that's what we're asking for.
Anything you want to say, sir?
No.
He is currently still employed, works almost every day for extended periods of time. He does have 4 children that he supports. If I may add, Judge, that in reference to page 3 in his evaluations, in which he was evaluated, they came back as a low risk.
A low risk of what?
Right?
Ever committing such an offense?
Evaluation prognosis in which through the Texas risk assessment system, it came back as a low risk level. As the court is aware, they usually come back kind of high sometimes, so a lot of times. He does have ties in this area with his parents or his mom still here, though his father's still in Illinois, and also his 4 siblings that are still in Delta.
It's interesting on the pre-sentence report, and by the way, the pre-sentence report is part of the record for all purposes without objection. The report states that according to the defendant's version, he wrote to the police in his statement that I met the girl. His father was okay with me dating her. Maybe it was her father.
Her father.
He didn't have any objection at the beginning. They both knew my age as well. When he did have something to say, we ended the relationship. I did not think I was doing anything wrong at the moment. But in looking at the police report here in the pre-sentence report by investigator L.D. Keen, K-E-E-N, it was the father who called the police and reported the situation with his daughter. Obviously, the father was...
Well, something happened between the father and him, which escalated. If you looked into the police reports, they were going places, they were dating on that. And that was discussions that I had between the district attorney and myself, and something like. And he did say, I didn't know I was doing at the time, and he didn't realize it, that you can't be doing that.
Who's he? He said, no, I'm sorry, he's having sexual intercourse and ejaculating inside her at 14 years of age.
Absolutely.
He didn't understand and appreciate that might be wrong or illegal.
No.
Even looking at his statement in the pre-sentence report, that first little sign, that first line that his nephew interpreted, it said, I was with a minor.
Right, because that was after I had to explain to him, after he retained me. No, because that was one of their, not getting into current client privilege, but that the statute says you can't do that. And that's the reason why we're here today with a plea, because it is wrong. And he acknowledges that, but at the time it happened back in 2020, well, I'm 25 now. And him living at that residence, it was a different set of facts. Certainly, I mean, understand. After the fact, you realize, and that's, again.
I understand,
You
but
know,
just nature being the way it is, it was amazing she wasn't impregnated.
Absolutely.
So at 14 years of age,
Absolutely.
and then how does everybody explain that away legally? It doesn't. It's just not the way our laws. Anyone under 17 is a child. Under 14, you are all aggravated type offenses. This child was 14, but nonetheless, the historical reasons for this type of law are just morally based, that are American fundamental moral rights that are believed to be,
And I agree with
decent versus indecent. The state is asking for
5 years.
and
for 10 years, Judge.
all right. Is there anything else you would like to add, Mr. Salinas?
No. No. ¿Quieres decir algo?
No sé, pues como mi muchacha ya había tenido dos parejas civiles y mayores, ¿no?
She previously had two other partners who were also older gentlemen.
That makes it right?
Yes, o quiero decir que es como,
Sí,
Oh, you think that makes it right?
¿tú piensas que eso es correcto?
como correcto.
Estar con una propiedad.
No,
No.
No. That doesn't make it right. Adults are supposed to be responsible. Children aren't held to that same responsibility. They're children. Adults are supposed to have self-control and follow the law. All you did was victimize a child twice for your prurient interests only. You have pleaded guilty voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted during your plea hearing to find you guilty beyond a reasonable doubt, and I now find you guilty beyond a reasonable doubt of this most serious offense of sexual assault of a child, a second-degree felony. I am following this agreement. You are hereby sentenced to confinement in the Institutional Division of the Texas Department of Criminal Justice to serve a term of 5 years. You must register as a sex offender in the state of Texas. Failing to properly register and continue to register as a sex offender places you in a situation where you can be charged with additional felony offenses for failing to properly register as a sex offender. Do you understand, sir, what has happened today? You can't hurt, you can't victimize a child without being held responsible. It's clearly an indecent thing that happened, which has its accountability under our rules and what we believe in as the leading country on this planet. You have to show self-restraint, act responsibly, and follow the laws, and don't hurt a child. That is all.